Hey guys, welcome to Parawomenradio. I'm Amy. Today we're going to go back into live court with the Suitcase Sarah Boone um, trial. The court is starting to record, so I'm going to bring that right up on screen. We're not going to do an opening today. So, let me get it all set up for you guys. How's everyone doing today? Happy Tuesday. You got Amy and Junebug here with you. It's a daytime live, so you're going to get the little bird. And today is a motions hearing for Sarah. Hold on one second. Let me see if it tells what the motions are for. I just saw that this was happening, and so I wanted to go live right away, so I'm a little unprepared. And I do apologize, and I'm without caffeine, too. I'm uncaffeinated. Okay, no, that's old. No, it's not really saying what it is going to be, but it's a motions hearing for today. The Florida woman accused of suffocating her boyfriend to death is set to appear in court today for a motion hearing. Just as Sarah Boone allegedly unalived Jorge Torres, often known as George, by zipping him up in a suitcase and leaving him inside to die after a night of drinking at her house in 2020. Boone briefly represented herself, and she retained a new defense attorney, and she's pretty pleased with herself. So we're just waiting for them to come into court. The recording has started in the courtroom, but the judge has not entered yet. I don't know if Sarah's there yet because they're not showing her. In her last hearing, she was finally sitting at the table with a lawyer in between her, and must have been the attorney's assistant, and she was pleased as can be. In fact, let me show you a little bit of that as we're waiting. The table. She's probably thinking that to herself. I'm finally sitting at the table. They finally invited me, the star, Sarah Boone, Blaine Boone, Suitcase Sarah, to the table after 4 years in prison. So, hold on. This isn't working. This isn't showing up. Let me get you back to here while I figure this out. Okay. We are waiting for court to start. It was set to start at 9 o'clock, and the recording has started in the courtroom. This is a motions hearing for Sarah Boone. Her trial is set to start October 3rd, I think. So she's screaming up on that date finally. The judge has been I'm not giving you any more time. You had 4 years, lady. 4 years. All you get. But while we're waiting, let's look at her last court appearance where she finally got to come up and sit at the table with her lawyers.
The court did receive the state's response to the motion to return property, which just filed yesterday, and the state's amended notice or amended motion to strike the amended notice of battered spouse defense. The court was reviewing the authorities cited therein, which is why we're a few minutes late this afternoon. Are there any housekeeping matters, state, that we need to address before we begin this afternoon?
Not from the state.
All right, any housekeeping matters from your side of the ledger, Mr. Owens?
Judge, I appreciate being here, and I just wanted to introduce my two assistants that are helping me, Shelby Andrews and Lauren Henderson.
Afternoon, y'all.
So he has an assistant.
Anything else, sir?
I mean, I feel like he's here to win this.
To the extent we may be hearing
course
from Ms.
he is,
Boone,
but-
ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and swear you in.
Sarah Boone is so happy.
Okay. I believe that the first thing that was filed in this case, just as a matter of time, was the state's motion to, the defendant's motion for statement of particulars. That was filed on September 2. I've reviewed that. Mr. Owens, you may proceed, sir.
Judge, do you want me at the podium?
However you feel most comfortable, sir. But because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars. And in my motion, I quoted the language in the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act imminently dangerous to another and invent.
Okay, this is interesting. Court is getting ready to start, and it's a different judge, you guys. It's a different judge. What do you think about this? Did we lose the other judge? I want to say judge, but I think that's the judge in the Kohlberger trial. Can't think of Kranick, Judge Kranick. Good morning, everyone. We are going into live trial this morning. This is the Sarah Boone trial in Florida. She's the Florida woman who zipped her boyfriend up in a suitcase and left him there to go to be unalived. And she's got a motions hearing today. Looks like it's a different judge.
Sorry, I've got to log out of WebEx and log into a different account.
Not sure why we have a different judge, but I'm sure we'll find out. It would be really nice if this finally goes to trial in October. Do you guys think that it's finally going to happen? She says she's logging out of something.
Okay.
In no hurry at all. Just kidding.
Finally in the right room.
I don't know. Are we in the right room? Because I don't recognize you, Judge, whoever you are. Did they get a judge?
Thanks for waiting. I'm happy to know that you're
Hi, everyone. Hold on. I am muted. Cut that off. Can you hear me? They cannot. Can you hear me?
What's wrong? Your Honor. Echo.
Maybe Sarah's
All right,
not.
let me figure out what's going on. It's already muted. Uh-huh.
Sounded better before whatever you did, what you
It
did.
is indeed.
I don't think Sarah's. I think this is a remote hearing today. It's just a motion
Now
hearing.
it's
It's
on.
not the
Now
actual.
it's on.
Judge, if I'm hearing there's a big echo from your part. You're hearing the same effect over here.
We're waiting for the judge to get it together. We're Sarah Boone hearing. So the judge is trying to get her equipment ready.
Testing. Can you hear me?
Yes, Your Honor, that's much better. Yeah, get on it.
All right.
Yes.
Figured out the problem.
Okay, I'm trying to.
Okay, we are here first on 2019 CF 7626, State of Florida versus Shamik Anderson. If I could have JAC identify himself for the record, please.
Yes, Your Honor. Christian Lake, Assistant General Counsel of the JAC.
Thank you. And who is here on behalf
What?
or seeking attorney's fees on that case?
Me, Judge.
This is the wrong courtroom. Long.
All right, and can, Mr. Lake, can you hear him?
He's very faint, Your Honor.
All right, if you could just talk into the microphone, that would be helpful.
Certainly.
Feel free to stay seated if you
I
like.
don't think
Um,
they're in the right courtroom for law and crime. I don't even know how to get us there because of the other channel, Court TV. I don't see that they're even covering it. So maybe there isn't a let me see if they're in a different courtroom, because it seems like, I don't know. Let me see what they're doing over here. They're saying Sarah changed her name to Shamik. I don't know. I'm gonna play the past Sarah Boone interview or trial hearing, and while I look to see if I can find her in any of these courtrooms. I'll be right back, you guys.
Life did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case. I know anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres. This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase, asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone.
I do see in doing searching, I do see that she is set to be in a hearing, and she's probably in it right now, and at 9 a.m. today, but they're not up there. The court TV is in the wrong courtroom. Let me see. Let me see if they get to the right courtroom. No, they're staying with it. Maybe this is going to happen. No, because why would the judges switch courtrooms all of a sudden? I don't know. What's it say? Yay, confirmation. It says relax. Boone should be on the docket at some point. Let me see. Law and Crime said something. The court appears to be handling another case. Boone should begin shortly. Okay, so we are still waiting for the Boone trial to begin. What's going on in the courtroom now is a different case. So while we're waiting for Boone to begin, I will keep an eye out for it. We're going to go in and we're going to watch her last hearing, where she finally gets up to the table with her lawyers. I don't think we watched this anyway together.
That the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres? And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, Pajon, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 7.
And because they did basically nothing on the case. The three of us did a lot of work in the case. As I said, I put in 175 hours, and even at the $75 an hour compensation, we're looking at $14,000. Spent a lot of time with Ms. Boone and a lot of time on the case. So I'm requesting a flat fee in this case.
All right, thank you. Mr. Hobson.
Good morning, Your Honor. Good morning, everyone. Your Honor, I got the case from Mr. Bankowitz, and I got the same information. The information Mr. Bankowitz just recited that he had. Reviewed, and in addition, of course, his information on top of all of that. I spent some time with the defendant at the jail. I spent a tremendous amount of time with the investigator reviewing the case, talking about discovery, experts, and so forth. I spent a tremendous amount of time with a proposed expert, Dr. Linda DeRay. That it turns out the defendant didn't like her. I thought she'd be great. We talked for dozens of hours, almost daily, extensive periods of time, coming up with theory of defense or theories of defense. At the in fact, you come.
Is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There is no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced. And they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to
issues that always has to be addressed when there are multiple attorneys, and I was the 8th attorney, and the 4th private court-appointed attorney is making a case that is old by purposes, for reasons of being on the docket for a long time, a priority, and putting aside other work. One of the unusual things about Ms. Boone's case was when I did withdraw for ethical reasons, the court found that she had forfeited her right to an attorney. She is charged by information with second-degree murder. There was an unusual amount of media attention on this case. The facts are she's accused of putting her boyfriend in a suitcase. He later dies. There is a video of this that went viral. Because the video went viral, because of coverage by Court TV, News Nation, Fox, the local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to review not just the banker boxes of discovery and work done by the previous attorneys, but stay up to date.
Sorry, I didn't realize my mic was muted. Good morning, Mally. Good morning, everyone. What's happening here is that we're at a motions hearing, and all her past lawyers are now sitting in front of the judge. Well, this is one of her past lawyers, is sitting in front of the judge saying, I did work for her. I deserve to be paid. So there's, I don't know if Sarah Boone is going to be here today or not, but this is what's happening.
With what potential jurors were viewing if they were watching it on the internet. There was a lot of correspondence between the defendant and the court. Obviously, I had to review all that. The most recent piece of correspondence when I was Ms. Boone's counsel was the 58-page letter that she wrote. And again, all these letters are published, they're analyzed. I, like previous counsel, spent an inordinate amount of time with Ms. Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be confiscatory to not pay me the flat fee. And having provided the requested proof based on the procedure for reimbursable costs, It's my understanding that Mr. Lake is not objecting to me being reimbursed for the $1,800 that I spent to retain an expert who did not have a contract with JAC.
Thank you. Mr. Lake?
Yes, Your Honor, just briefly. But as far as the issue of the $1,800, JT has no objection to that reimbursement. That's more of a technicality. The court did approve the expert. This is just the attorney getting reimbursed for expense that we have no objection to. So that's a non-issue. But you see that in the order. As far as the fees are concerned, the issue here is that other than Ms. Cashman, who submitted an hourly statement of 118 hours, none of the other attorneys actually submitted hourly statements, so we are kind of constrained by the statute. The problem is the statute only allows up to 200% of the flat fee in the absence of hourly statements. In other words, the way that the statute is worded very unusually, but essentially what it says is the court can award up to 200% of the flat fee without, and then it can only go above that if it finds that the case is confiscatory, and then can compensate the attorneys at a rate of $75 an hour. So that's where we get into a little bit of a difficulty here, because double the flat fee here would be $30,000, which is less than each of the attorneys is requesting $15,000 each, would be $45,000. As far as, and at that point, looking at the statute, what we have is Ms. Cashman, she got 118 hours in. That would represent at a rate of $75 an hour, $8,850. Based on Mr. Bankowitz's statement, he has 175 hours in, which would be $13,125 at that rate. And Mr. Hobson, he just basically said about 200 hours, which would be $15,000. That's the issue, Your Honor, is that, I mean, technically compensation has to be at a rate of $75 an hour for it to go above $30,000. And so beyond that, I mean, ultimately, but we leave it to court discretion to determine reasonable fee for each attorney, and we acknowledge that this. I don't think we can even begin to dispute that this is not an extraordinary unusual case. It's just that what the statute says is how the compensation structure is set up, and we have to argue that the court needs to follow that structure.
Mr. Lake, if one bills hourly, can the others be flat fee under your interpretation of the statute?
That until you get to double the flat fee, yes, at work. But once you go above double the flat fee, then at that point, it really should be compensation, should be 75 an hour. However, we also acknowledge that we have had other cases like this where the court has awarded the full flat fee to each attorney, and we've never taken it up. So I mean, it's essentially, we have to argue that you can only go to 200% of the flat fee, and at that point, it has to go hourly. But we also acknowledge that realistically, there is no attorney on the other than somebody who might take the case pro bono for other reasons. There's no attorney on the surface of this planet that would take this case for $15,000.
Your Honor, if I may address.
I don't
The
need
court.
I don't need to do that, Mr. Hobson. Thank you.
Yes.
I am going to award the $15,000 flat fee to Mr. Bankwitz and Ms. Cashman, and a $15,000 hourly fee to Mr. Hobson. Ms. Cashman will be reimbursed her $1,800 in costs. I will issue an order to that if on each of these cases. You've sent me orders electronically, and I will e-sign them. I've got it here, and e-file them in just a moment. Mr. Lake, do you have any questions?
No, Your Honor.
All right. Anything further with regard to this matter?
No, Your Honor. Your Honor, I would just state that I'm not asking for this cost, but I paid over $400 in photocopy fees costs for material that I sent to Ms. Boone along the way. But I'm not asking for that to be refunded to me.
All right. Thank you, Mr. Hobson.
Thank
All
you,
right,
Your Honor.
thank you. And we have one last hearing. Let me just enter these orders real quick.
I don't even think Sarah
All
Boone's
right, the
gonna be
last
here
case on the
today.
docket is 2022 CF 11594, State of Florida versus Alfredo Torres Eusebio. Mr. Lake, you're here for JAC?
I am, Your Honor. And this situation is essentially the same as one we just had.
And Ms. Cashman, you're here on this case.
Yes, I'm requesting the $15,000 flat fee, ma'am.
All right. And Mr. Hobson, are you on this case as well?
I am, Your Honor.
All right. And who?
Okay, I think that's all that was just the lawyers trying to get their money, which they totally deserve to get their money. Okay, guys, I'm gonna go. I actually have some shopping to do, and I am working on a video to get out for you guys today. So I'm gonna go. I love you guys so much, and I'll see you later. Bye, guys. Hi, guys. Welcome to Parawomenradio. I'm Amy.
Carefully strumming this old guitar, words rolling out into the fire. Never asked why my heart burned blue. Here in the haze where you inspire me. Here in the darkness I hear my cue. Time to find some solitude. Here where my soul bleeds openly. Deep in the heart of sin and you. Here in the blue, I'm falling deep into you. Here in the blue, I'm dancing with you tonight, and it feels fine. Carefully strumming this old guitar again.